Well, without further ado, I will introduce our speaker for this evening. Dr. Mark Brilliant comes to us from UC Berkeley. However, his life began on the East Coast. Professor Brilliant was born in New York City and holds a bachelor's degree from Brown University. From 1990 to 1994, he taught social studies at Lafayette High School in Brooklyn, New York, before heading west to Stanford University. In 2002, he earned his PhD in history and then spent 2 years at Yale University as a postdoctoral fellow and lecturer in the history department. In September of 2004, Professor Brilliant returned to California, this time as an assistant professor in history and American studies at UC Berkeley. In September of 2010, Oxford University Press published his first book, The Color of America Has Changed, How Racial Diversity Shaped Civil Rights Reform in California, 1941 to 1978. It also happens to be the title of his lecture this evening. The book won the Cromwell Prize from the American Society for Legal History and received honorable mention from the Organization of American Historians for the Frederick Jackson Turner Award. We are very fortunate and grateful to have him here with us tonight to cover topics on his award-winning book, as well as to provide a context of Nathaniel Colley's life work. So please join me in welcoming Professor Mark Brilliant.
Well, good evening, everybody. Is that okay? I'm used to moting to a lecture hall of 350 people, so I really don't need this, but if I will keep it far away. If it gets too loud in the back, just wave your hands. I want to begin with a first-person account of a post-World War II migrant to Sacramento. When I arrived here with a law degree, I had great difficulty in even getting a brochure which told about a state examination for junior lawyers. When I asked for one, the lady at the counter told me that they were only given to those who had already graduated from law school. When I assured her that I had, she said, "I mean an accredited law school." She only yielded when I offered to bring down my Yale degree with honors written in Latin. And though he doesn't say it, he was probably thinking, and I would translate it for her. I took the examination, and for a whole summer I was number one on the statewide list, but no state agency would have me. One big fat cat with a hippopotamus intellect brushed me aside on the ground that the job required a lot of writing and a proper command of the English and legal languages. He would not listen as I tried to tell him that one of my honors at Yale was the Benjamin Sharp Prize for the best essay written by any Yale Law School senior. It was crass, open bigotry which forced me into the private practice of law on my own. That person, of course, is Nathaniel Colley. And when I read that autobiographical account as a graduate student, I was immediately drawn to him and wanted to learn all sorts of things about him, as well as the other figures. I try to do that with any of the people I'm writing about, the litigators, the politicians, to get behind them, to know where they come from and how that shapes what it is that they do. I was able to find it in a lot of cases. In the case of Nathaniel Colley, unfortunately, I couldn't. There were published accounts. There were some records in the NAACP collection at the Bancroft. But the records that are now here weren't available to me then. And so I want to say special thanks, as I know it must be, I can't imagine how hard it is to part with the records of your father. But I imagine. But I want to say that it's not possible to do the historical tribute to people like your father without it being in a place that's accessible. And so thank you. And for those of you who have other written documents that he was involved in, I suggest bringing them down here and bringing, it's actually, he's referred to, as in the speech he's referred to as Mr. Civil Rights in California in his modest way. He said, well, actually, no, I'm not. Loren Miller is. And I'm going to talk a little bit about Loren Miller, who was his predecessor and co-litigator in a number of cases. Loren Miller's papers, which were recently processed at the Huntington Library in Southern California, are 80 boxes worth. They're treasure trove. And so over time, hopefully, the Colley boxes will grow and grow. There's much there. There's no way that his life can be encapsulated in 6 boxes. And this stuff is out there, and maybe in someday it will make its way over here. But what's there is great, and I wish I had it to me to know more about this person. And in the Q&A and in the discussion afterwards, I look forward to hearing some of those stories. What I'm going to do, since I don't have enough to work with a whole talk on Nathaniel Colley, is I want to try to place his life within the context. It's really less about him in the context of California civil rights history in the post-World War II period, right up through the Bakke case in the 1970s. And so that's the context into which you think about Colley, and that's going to be the real thrust of our remarks, which will run about 40 or so minutes, and then there'll be some time for Q&A, and I gather there's a book signing afterwards, which I've never done that before. So to my mother I've done it, but so I'm somewhat embarrassed by that. So as Dylan said, after I was an undergraduate, I taught high school in a large public high school in New York City. And it was there, actually, that the idea that evolved into the book that I want to talk about tonight began to emerge. I had an extraordinarily diverse student body, as one would expect, in a place like Brooklyn. There were all of these sort of debates going on in the early 90s about the sort of historical content, the kind of stuff that Nathaniel Colley was involved in, expanding the curricular content in a more multicultural way. And one of the questions I began to wonder is, well, what would happen if you tried to tell a civil rights history that was multicultural rather than bicultural? One that included, but was not limited to, African Americans and their white allies and opponents in the South from the mid-50s to the late 60s. The textbook I taught provided few clues to help me answer that question, nor did any of the historical monographs, really, that were available in the early 90s to supplement my lesson planning beyond the textbook. One of them, for example, here you have a map from one of these classic civil rights history monographs, sites of the civil rights movement. If a picture could say 1,000 words, it tells us, the civil rights movement was something that was confined to the American South. So these kinds of textbooks reflected what historians of civil rights in more recent years have sort of referred to as a kind of dominant narrative of the civil rights movement, geographically focused on the American South, racially focused on African Americans, and chronologically focused on the years from the mid-1950s, Brown v. Board of Education, the Montgomery bus boycott, to the sort of major legislation in the mid-1960s. The dominant narrative still persists down to the present, especially in the popular culture, as evidenced by this particular map put out by the National Park Service on historic places of the civil rights movement. To be sure, this map covers a bit more territory than the previous one. For example, New York appears there, Nebraska. Anyone want to hazard a guess? Birthplace of Malcolm X. And that epicenter of civil rights history to our east, Nevada. But not California, nor almost every other state in the West. Did no civil rights movement history happen in these places? The inclusion of New York, Massachusetts, Illinois, amongst other states in the North, reflects developments in the civil rights scholarship in the last 10 or so years. Historians have turned their attention beyond the South to the North, and they've advanced what they refer to as a new, long civil rights movement interpretation. It locates the civil rights movement's origins during the New Deal era and its acceleration during the World War II period, rather than the mid-1950s. It emphasizes how the movement's reform aspirations were broader than simply the striking down of statutory segregation or Jim Crow. And it highlights the breadth and depth of civil rights struggles in various northern locales that occurred contemporaneous with, rather than subsequent to, those in the South. And this is a book that is a kind of synthesis of a lot of that scholarship, but it's still coming out in droves. As important as these revisions have been to the kind of dominant narrative of the civil rights movement, they remain incomplete. In particular, the efforts of long civil rights movement historians to direct our attention northward has either left the West out altogether or simply conflated the West with the North defined as anything outside the South. Yet, if racism and the attempts to combat it manifested themselves in different ways on either side of the Mason-Dixon line, they took even more variegated shapes in those places disproportionately located in the Southwest and along the Pacific coast, where the race problem, as it was referred to in the 1940s in singular, was never simply singular. It was never simply synonymous with, nor reducible by analogy to the Negro problem, as it was also referred to in the 1940s. Perhaps the first person to recognize this most clearly was the California-based journalist and activist and lawyer by the name of Carrie McWilliams. What Americans must realize, McWilliams wrote in Brothers Under the Skin in 1943, what they can no longer afford to ignore is the simple and obvious fact that the color of America has changed. McWilliams' pronouncement was as prescient as it was anomalous. Presciently, it anticipated by a half century a course of similar statements made by journalists, scholars, and policymakers commenting on the changing demographics of the United States, in effect, the United States coming to look more like California. And anonymously, McWilliams' work cut against the prevailing view of the race problem in the 1940s and for years after, for that matter. To most Americans, wrote a reviewer of Brothers Under the Skin, the race problem means only the Negro problem, and few even know that the term colored people applies to any races other than the Negro. No book published in the 1940s did more to reinforce this understanding of the race problem as the Negro problem than Gunnar Myrdal's 1,500-page landmark study, An American Dilemma, which bore the subtitle, The Negro Problem and Modern Democracy. Unlike Myrdal, however, who approached the race problem from the former Confederacy, McWilliams wrote from America's racial frontier as he referred to the West in general and California in particular. And from this vantage point, he argued, we have overemphasized the Negro and failed to correlate the Negro problem with the race problems besetting other colored minorities. Implicit in McWilliams' pluralization of the race problem is the question or questions that really at the heart of my book project. And that question goes like this, and I'm going to try to answer this question in the remaining time. So you don't have to, well, you can buy the book. I don't get a lot of royalties, so that's not a big deal, like 5 cents on the dollar. I'm not making off with it. But I'll give you a real sort of nutshell, sort of distillation of it in the time remaining. So the core question is, how did the multiple race problems found on America's racial frontier shape and complicate the efforts of civil rights reformers in the decades that began where Brothers Under the Skin ended? Another way of asking that question is, what does civil rights law and politics look like in a multiracial context like California? And so what I want to do is I want to spell out my argument in 5 to 10 or so minutes, and then I want to try to give you a little sense of how that argument unfolds over the course of the book. So the argument, the thesis, goes like this. In the large swaths of the United States, where the race problem was indeed one and the same with the Negro problem, civil rights reformers could and did concentrate their attention on it. Their efforts rendered resolving the so-called Negro problem synonymous with the civil rights movement. In California, however, the presence of multiple race problems, each of which tended to attach themselves to the state's different racial groups in different ways or in different degrees, that militated against the making of any kind of cohesive, singular civil rights movement. Another way of thinking about this is a kind of question of, why don't you see in California anything like the kind of movement that sociologists who study movements would say happened in the American South. Kind of upwelling, a kind of social movement. Why don't you see it in that same degree? It's not because there wasn't racism. It's not because there wasn't racism codified into law. It wasn't because there weren't anti-racist activists working on this. Why don't you get that here? And that's sort of what I was trying to sort of wrestle with, another way of asking the question at the heart of my book. What you get instead is a diverse and largely diffuse, scattered set of civil rights struggles which don't really come together in any meaningful way. It's like a set of separate streams that don't come together. And I think when you look at California and you want to think of California as part of America, that it compels a rethinking of America's civil rights history as not simply long, which has been the move in the recent scholarship, but also, and this is the core sort of claim in the book, wide. I talk about a wide civil rights movement. What I mean by that, if you think about the civil rights movement nationally through the lens of California, is that the movement was wide regionally, meaning that it was a truly national phenomenon. It was wide racially, meaning that it encompassed more than blacks and whites. And most importantly, it was wide substantively, meaning that it involved a broad range of race problems and therefore responses to them. On this last point, it's not enough to widen the regional and racial lenses for apprehending civil rights history, but then simply view other non-white groups in other places as analogous to African Americans in the South. You can't say, as go African Americans, so go these other groups. That was a standard move, as you'll see, but it doesn't work, analytically speaking, as I'll try to explain. When I say that the civil rights movement as viewed from California was wide substantively then, I mean that racism tended to afflict the state's different racial groups in different ways or in different degrees. These different experiences with racism in turn translated understandably to different civil rights priorities and pursuits. Different axes of discrimination are really, as students say, well, if you want to boil down the book to one sentence, it's different axes of discrimination led to different avenues of redress. And that has profound meaning and sort of implications for the nature of how to understand what civil rights in a multiracial setting looks like. California's diffuse pattern of civil rights making, the different avenues of redress that flowed from these different axes or forms of discrimination, was not for the lack of trying to forge something more cohesive, more like a movement. Indeed, from the 1940s forward, California civil rights reformers across groups issued frequent calls for coming together, for unity, and engaged in kind of fleeting responses and efforts to join forces. These California civil rights reformers often spoke the same general anti-racist language which scholars refer to as racial liberalism. Well, we have moved away from laissez-faire doctrines in economics, wrote Carrie McWilliams about the changes wrought by New Deal liberalism. We still anachronistically pursue laissez-faire theories in population matters. Racial liberalism, in other words, was a way to extend the kind of New Deal liberalism of the 1930s to include those racial groups who had been excluded from a whole range of New Deal programs, and to address the issue of state intervention on behalf of population matters, which is a reference to the state should play an active role in undoing racial discrimination. McWilliams referred to this racial liberalism as a movement to outlaw racial discrimination by direct legislation as well as litigation. Right? The New Deal had made a big move in saying that the state had a role to play in regulating the economy. What racial liberals were trying to do is to extend that logic and say the state has a role to play in undoing racism through various forms of anti-discrimination legislation and litigation. So racial liberals spoke this general type of language. They spoke about equality of opportunity through anti-discrimination, litigation, and legislation. they often analogize the plights of so-called colored minority groups. That is, they accentuated the racism in general that each group faced in order to help build coalitions across groups on behalf of particular forms of anti-discrimination litigation or legislation. The Japanese American Citizens League, which was an anti-racist group that was operating in California in this time, said discrimination or unfair treatment against any minority redounds to the detriment of all minorities. Right? This is a language of coalition building, of trying to do that work. What was in the civil rights interest of one minority, in other words, was also in the civil rights interest of other minorities. And in theory, that provided the basis for the forging of some kind of interracial, multiracial movement. In practice, however, the analogy and its presumption of a harmony of civil rights interests across racial groups, and in turn, a kind of natural alliance between them, could only be pressed so far. As those same Japanese American Citizens League attorneys acknowledged, each of the state's racial groups confronts problems that are varied and different from one another. How do you square that circle? In many ways, is the problem, sort of the challenge of racial diversity or racial liberalism. It's the tension that I'm exploring in the book. Though California's civil rights reformers might have been united behind the ultimate ends and means of racial liberalism, they often found themselves divided over specific anti-discrimination measures to privilege in their litigation and legislation agendas. Distinctions without much of a difference on the diagnostic side, variations on a kind of general theme of racial discrimination, proved to be distinctions with a difference on the prescriptive side. Distinct civil rights priorities reflected distinct experiences with racism. Different axes of discrimination, to reiterate, led to different avenues of redress. And this is what I refer to in the subtitle of the book, and sort of allude to it there, is the kind of challenge that racial diversity poses for the project of racial liberalism, or an anti-racist civil rights type of project. For this reason, though the separate streams of California's civil rights struggles occasionally crossed, they never converged into a civil rights movement river. This lack of confluence, however, did not preclude the realization of consequential civil rights reforms. Nathaniel Colley's life is a great testament that one doesn't always need a social movement to effect profound change. You can do it in a variety of ways, like being a litigator. Nor did this lack of confluence owe to a dearth of lack of efforts to build interracial coalitions in order to forge a statewide multiracial civil rights movement. Right? There were those efforts. They just never came together. And so that's the sort of the big picture, the big argument. And what I want to do now is try to give you the ground. I know it's somewhat maybe abstract. I want to ground it and come on some of the specifics of specific pieces of litigation and legislation to give you a sense of how this argument sort of unfolds over the course of the book. History oftentimes, especially historical writing, is an exercise in tell and show rather than show and tell. You first say, here's what I'm arguing, and then you say, and here's how the argument, of course you don't get to the argument until you get right at the end of the book, and then you insert it in the intro, but that's a different story. So my book begins with the founding and the foundering of this organization, the California Federation for Civic Unity. Nathaniel Colley, in fact, was president of this organization at one point in the late 1940s and early 1950s. My interest in this short-lived organization was that it was one of dozens of similar anti-racist organizations that cropped up in California and cropped up nationally. But what thank you. Sorry. What distinguished it from the other groups was that it was really statewide, and it made a concerted effort to try to pull together the efforts of the NAACP and the Japanese American Citizen League and the burgeoning groups advocating for Mexican Americans to try to kind of find common ground. But from its inception, it confronted the difficulty of doing that. One San Francisco NAACP leader, who was also a leader in the California Federation for Civic Unity, described this organization's goal as building a united front of all the minority groups in California. That goal, however, foundered in the face of the wide range of race problems those minority groups confronted. Right? Those groups ultimately had to make decisions given the fact that they had limited resources. People were doing this on a sort of voluntary basis. They would join, they weren't professionals. And that the state was not particularly open to civil rights reform. I mean, on a list of public opinion polls in the late 40s, jobs, of course, was number one. But, you get to the bottom of the list and you have traffic, and below that you have racial issues. So they have to make the limited resources. They're sort of speaking a kind of common goal agenda, but ultimately they have to pick what are going to be our civil rights issues to pursue. And so this group, which had all of these sort of noble ideals of building a united front of all the minority groups, of forging what one of its leaders referred to as a new human rights movement in California, would find by the early 1950s its same leaders were lamenting the fact that there is, quote, almost complete isolation between the state's various racial and cultural groups. By the mid-1950s, a year or so after this picture was taken, and I suspect if someone wanted to look real carefully, you would find Nathaniel Colley here. Right, they met every year along the California coast near Big Sur, and they would try to kind of figure out what's going to be our agenda. Someone see him there? Yeah, right up front center, is that it?
Middle.
Right there.
Right there.
Right? 1 year later, this whole thing disbanded. Right? You can see in the faces of who's involved, sort of in some ways, it's an embodiment of this kind of goal for, but it fell apart by the mid-1950s. They couldn't figure out what would be the kind of common ground issues that we could go back to our local communities and say, this is what we're going to all pursue. The cover image of my book, if you've ever been to the Rincon Postal Annex in San Francisco, Anton referred, this is one of the pictures there, and what I love about it is that it really is, it reflects one part of the book, the part of the book that's about what the CFCU was trying to do. Right here you have a family that is sort of a representation of what anthropologists in the 1940s would have referred to as the races of mankind. Quite literally embodied in a family, right? Looking forward kind of hopefully to the future. In some ways, that's what the CFCU embodied. And in a lot of ways what the book is about is why doesn't that really come to fruition? This image, just as an aside, for those of you who know, it's a riff on Norman Rockwell's Four Freedoms. It comes out a year or two afterwards, and obviously, unlike Rockwell's white, this sort of homespun image, it is a very California multicultural sort of rendering of the Four Freedoms, and that was done very consciously. In any event, while the CFCU was groping for common ground, lawyers representing Japanese Americans, Mexican Americans, and African Americans on separate tracks spearheaded a series of separate cases that unfolded over the course of the second half of the 1940s that challenged California's system of statutory segregation. These parallel efforts, that is, they don't come together, provide early evidence of just how elusive that aspiration embodied by the CFCU was. One of those cases challenged California's alien land law, which really was a law that targeted Japanese and barred them from being able to own or lease land because they fell into a legal category that African Americans didn't fall into, which was they were, those who were Japanese immigrants, aliens who were deemed by U.S. courts to be racially ineligible to become naturalized citizens. So they're fighting a form of statutory segregation that really targets Japanese immigrants and, by extension, their American-born children. It's a case that goes to the Supreme Court in the late 1940s and scores a major victory. And so I talk about that case. For Mexican Americans, the big battle in the 1940s period was the segregation of Mexican school children in California public schools, which culminated in the Ninth Circuit Court of Appeals in 1947. Curiously, African Americans were not part of California's school segregation statute in the 1940s. So Mexican Americans were fighting a particular form of school segregation that they experienced largely in Southern California. And a lot of the legal basis for the segregation was that they lacked adequate proficiency in English, and therefore they were being segregated on the basis of their lack of English skills. So legally speaking, this was a very different species of school segregation than the one that the NAACP was involved in on the road to Brown v. Board of Education, although the NAACP does file a brief in this case as it goes up to appeal before the Ninth Circuit. So the lawyer in the case. This is actually a funny story. The reason I have this picture is, at some point, someone wrote that he was an African-American civil rights attorney. And so then every other article reads it one time and writes, this is why I go to the original source. So I tracked down a family member and I said, I heard your father's African-American civil rights. She said, what? He's an immigrant from Russia, he was Jewish. So there he is. So, it's like an echo chamber. Once one person says it, it's like history, and then everyone else repeats it. So all the more reason to get the records in the archive so we can go and consult, to go to the original source. The third set of cases in the 1940s that really were the cases that African American advocates were most concerned about involved racially restrictive housing covenants whose victims in the 1940s were overwhelmingly African Americans. The covenants had a much broader sort of racial language to them, but almost every time when someone was challenged for violating the covenant, it was someone who was African American. Sometimes the signatories to the covenants would be people who would have been, if you just look at the language, excluded, Jews sometimes, people with Spanish surnames. So this was, especially as the black population exploded in California in the 40s, a huge issue for African Americans who couldn't find a house anywhere to live because so many neighborhoods had these racially restrictive covenants. Loren Miller, who Colley said was Mr. Civil Rights in California, was the main architect of this litigation in the 1940s, which would ultimately go up to the U.S. Supreme Court, where the court said that the state can't be in the business of enforcing these kinds of restrictions. A hugely important Supreme Court case. Miller would be joined in the early 1950s by Nathaniel Colley, pictured here in 1964, as part of the NAACP West Coast Regional Office's legal redress team, and their focus in the 1950s was fair housing litigation. We talked about in the film, the Ming case, that was an important precedent. I'd also mention that in the late 1940s, California struck down, its Supreme Court struck down its anti-miscegenation law. It's a law that prohibited interracial marriage. It was the first state in the country to do that. So by the late 1940s, statutory segregation in California had been eliminated. Collectively, the cases that I've just mentioned toppled the state's matrix of legalized segregation, and in many ways they compressed in just a few years in California what would not begin in the South until 1954 with Brown v. Board of Education, and would not end in the South until 1967 with the case of Loving v. Virginia, which finally struck down the 16 states that still had prohibitions against interracial marriage. Right? California was done with this Jim Crow, statutory, legalized segregation by the late 1940s. But my point here, in part besides narrating the sort of legal successes, was just these were, despite the efforts to try to come together, these battles took place on separate tracks that reflected different experiences with racial discrimination. And that pattern would be a pattern that would persist into the 1950s and into the 1960s. And that's sort of a lot of what the rest of the book talks about. What happened in the 50s is California civil rights reformers said, okay, we're done with statutory segregation. Now let's start trying to enact various forms of anti-discrimination legislation. Fair employment, fair housing. These were, for the NAACP, the top civil rights priorities. The NAACP dispatched a protege of Thurgood Marshall, Franklin Williams, who became the head of the NAACP's West Coast Regional Office, where Colley was working as the head of with Miller as the head of the legal redress team. Williams himself was an attorney who had worked with Thurgood Marshall, pictured here. When Williams came from New York to California, he noticed, wow, it's different here. You've got all these different groups. And he's sort of puzzling over it. He says, but we can overcome that. We're going to have cooperation and unity, he said, in the pursuit of a common goal. That common goal, he said, is one of equality of opportunity for all people. But it provided that sort of broad language, insufficient interracial adhesive power. On the one hand, the NAACP pursued fair employment practices legislation through the 1950s and fair housing litigation beyond racially restrictive covenants as a solution to what Franklin Williams described as the most pressing problem for the Negro and other colored minority persons throughout the region, right? He's trying to say what's good for us is also good for you all. On the other hand, advocacy organizations for Californians of Japanese and Mexican descent belied this kind of reasoning by analogy in their pursuit of their own particular forms of anti-discrimination legislation that they saw as targeting the forms of discrimination that those groups faced the most. For example, in 1953, when Williams declared fair employment practices to be the #1 legislative aim of all the civil rights forces in California, think about that, right? He's making the fair employment practices. That is the #1 aim for all civil rights forces in California, right? This is effort to say we're all under this big tent. Meanwhile, the burgeoning Mexican-American Community Service Organization, which is the organization where Cesar Chavez was learning to become an organizer, launched what would become a nearly decade-long campaign on behalf of what it took to be its top civil rights priority, which was getting old age pensions, state old age pensions, for long-term resident non-citizens. A preponderance of those were people who were Mexican-born and come to California, had not become citizens, were now retired, and didn't have old age pensions, much less Social Security or anything like that. This was an organization created in the late 1940s by Fred Ross, who's pictured here. And he made it really clear that the purpose of this organization, he says, we don't have an NAACP for Mexican Americans. And we need to have an organization that targets their, as he put it, problems first, which were rooted in their peculiar economic, social, and political status. Right? So you have this sort of the larger goal they're talking, but when it gets down, the rubber meets the road, they're going in different directions. Okay? And that's the pattern, the 50s into the 1960s. When you get Pat Brown elected as governor in 1958, there's a real lull in the 1950s in terms of civil rights legislation. The state is sort of says, look, we're done with racism. We've got rid of statutory segregation. And so nothing happens until Brown becomes elected in 1958. He makes civil rights a top platform issue. He comes to office and he appoints Franklin Williams as his sort of main guy in the civil rights section of the constitutional rights section, which he creates, which is basically a civil rights section in the California Attorney General's office. And Brown says top priorities are fair housing, or fair employment practices, which they get in 1959, and fair housing, which they get in 1963 after a titanic battle in the state legislature to pass the Rumford Fair Housing Act. At that moment, Brown's aides were sort of crowing about, look, no state is more at the forefront in the country in terms of advancing civil rights than California. But at that very moment, 1963, this high water moment for racial liberalism in California, Cesar Chavez was writing letters to Democratic legislators saying, and I'm quoting him here, when will the Mexican American receive some meaningful legislation from those Democrats whom they so loyally support year in and year out? Right? And for Chavez, the big issues, he viewed Mexican Americans as synonymous with the farm worker. That's almost a direct quote. And so there are a whole list of farm worker-related issues, improving minimum wage for farm workers, securing collective bargaining rights for farm workers. And that's where the thrust of his activism would go. It wasn't that he was hostile to fair employment or fair housing. It's just he was going down a different path and pursuing a different agenda. Civil rights issues would contribute to the demise of Brown and the rise of Reagan. Though a speechwriter for Brown would write in recollection of the years 1959 to 63 as a time when liberalism was rolling, it was not rolling in the direction that Chavez and an increasing number of Mexican-American leaders desired. Moreover, with the passage of the Fair Housing Law in 1963, liberalism, as many of you know, would be rolling off a cliff. Indeed, Ronald Reagan's trouncing of Pat Brown in 1966, sent in good measure from Reagan's support of Proposition 14, which rolled back the Rumford Fair Housing Law from 1963. It passed in a landslide. When the California Supreme Court overturned it in 1966, Reagan capitalized on the outrage the decision unleashed. All right, so there's a whole big battle. This is all at the Bancroft Library on Prop 14. Now, what's interesting here is while Reagan campaigned against fair housing, he also campaigned for a growing number of Mexican-American voters for whom the Brown administration had proven to be a disappointment on farm labor issues. There was lots of tension over the lack of a disproportionate underrepresentation of Mexican-Americans vis-a-vis African-Americans in state employment. And Reagan sensed that there was a constituency to be had here. And later, Richard Nixon will follow this sort of lead in trying to go and pick off Mexican-American Democrats for Reagan, as you see here. Right, so Reagan is seeing that. Brown is presuming that, I did fair housing, I did fair employment, right? I'm the civil rights guy. And Reagan is the one to recognize that there's this disaffection amongst Mexican Americans. And he gets, not a majority, but he gets unprecedented support for a Republican in the election of 1966. Now, up to this point, the civil rights stories I'm telling are largely these kind of separate streams that don't converge. But by the late 60s and early 70s, and this is sort of where the book comes to a close, these separate struggles, at least around two issues, did collide. During Reagan's first term in office, the NAACP switched its emphasis away from fair housing and toward what was known then as ostensibly de facto school segregation, which needed to be remedied with school busing. When school desegregation litigation that the NAACP pushed yielded victories that required busing in San Francisco in 71 and LA in 70, forced busing became to its opponents what forced housing had been in just a few years before. If busing to promote desegregation was not combustible enough in California as it was elsewhere across the country, it was complicated by the push for bilingual education. This was becoming a major issue as a result of the demographic changes ushered in by the change in the immigration law in 1965, which saw a large influx of immigrants from Asia and Central and South America. Bilingual education stood at least in tension, if not at loggerheads, with desegregation. The Mexican-American Legal Defense and Educational Fund, which had been formed as a kind of NAACP, LDF analog for Mexican-Americans, its leaders commented on this tension in the early 1970s as follows. The danger in multiracial school systems undergoing court-ordered desegregation is that the Chicano and Chinese minorities will be so dispersed to achieve desegregation that they will lose or fail to achieve needed educational programs, most notably what were then fledgling bilingual education programs. How to have them both is what they're wrestling with. Reagan took advantage of that tension when he was running for re-election in 1970. He insisted that forced busing would undermine bilingual education efforts, which, by the way, he supported, striking down California's English-only law, signing his name to bills that provided some kind of early funding for bilingual education in California. This tension between desegregation and bilingual education, notice the no forced busing here, unfolded in especially dramatic fashion in San Francisco in the early 70s. There, a desegregation suit brought in federal court in San Francisco by the NAACP encountered stiff resistance from members of the city's Mexican and Chinese descent communities. At the same time, a bilingual education case launched by attorneys acting on behalf of non-English-speaking Chinese descent students would go up to the Supreme Court in the 1970s and score a major victory. Lau v. Nichols is the case it's referred to as the Brown v. Board of Education for language minority students, providing Supreme Court approval and support for it, that there has to be some kind of bilingual programming or supplemental English language instruction. By that moment, when this issue gets to the Supreme Court, the mid-1970s, schools across the country began to grapple with this tension of desegregation and bilingual education. And I think at that point, Americans are waking up to what Californians have been grappling with for decades, right? The challenge of racial diversity for racial liberalism. And that challenge, I think, was very much reflected in the last case I want to mention here by way of conclusion. It's probably the most famous of all of the cases. 35 years after Kerry McWilliams declared that the color of America has changed, the United States Supreme Court confronted head-on the implications of that change. In the 1978 case, right out of here, UC Davis Medical School, 4 justices sided with certain sections of Justice Powell's opinion to cobble together a 1-vote majority on behalf of a narrow defense of affirmative action in higher education admissions. Thurgood Marshall was one of those 4 justices. But he also filed a separate concurring opinion. In it, he was very angry. In it, he blasted the limited reach of Justice Powell's ruling, which was a ruling on behalf of diversity as a rationale for affirmative action. Focusing exclusively on African Americans, Marshall described their history as, and I'm quoting here, different in kind, not just degree, from that of all other ethnic groups. For this reason, Marshall found it difficult to accept, and I'm quoting him here again, that Negroes cannot be afforded greater protection under the 14th Amendment where it is necessary to remedy the effects of past discrimination. He wanted affirmative action to be grounded not on diversity rationale, but to address the historic discrimination that he says is unique to African Americans. The exceptionally invidious history of anti-Black racism merited at least that much, was his argument. At issue in Bakke, however, was an admissions program at the UC Davis Med School that reserved 16 out of 100 slots, not only for Blacks, but also Chicanos, so the language of the program, Asians, and American Indians. Whether these other groups should be included alongside African Americans for affirmative action as a partial remedy for past discrimination, Marshall did not say, but that was the case before him. It was as if Marshall were too steeped in the Southern civil rights history he had done so much to make, to confront the full complexity, both demographic and by extension legal, of the California-based civil rights history that was being made in the case right before his eyes. By remaining mute on this matter, Marshall failed to address what I've described as the challenge of racial diversity to racial liberalism. Kerry McWilliams captured that challenge in 1947 when he asked, what should be the policy of the federal government toward racial minorities in a multiracial and multi-ethnic republic? 30 years later, this question cut to the core of Bakke and the complex multiracial civil rights politics and law that Bakke signaled for a country that increasingly resembled multiracial and multi-ethnic California. What Marshall avoided in Bakke, California civil rights reformers had been wrestling with since World War II. Their efforts demonstrated how California's, and by extension the country's, civil rights past must not only be understood as long, but also wide, as I've argued, wide demographically, wide geographically, and above all, wide substantively in terms of the different axes of discrimination and the different avenues of redress. Only through such a widened lens can this momentous period in United States history be apprehended as the national, not regional phenomenon, the national phenomenon that it was. Moreover, only through such a widened lens does a multiracial civil rights past that illuminates America's increasingly multiracial civil rights present and future come into view. Thank you.
We'll have a few minutes just for some questions. If anyone would like to ask Professor Brilliant a question or two, or we can do that now.
You ended with Waukee. There is now a case before the United States Supreme Court. It comes out of Texas. That basically focuses on the issue: should race now be taken up at all for consideration to admission into law school? Do you have any comment on that?
Well, I was joking when I saw Nat Colley's testimony about Anthony Kennedy. I said, I wonder what you think about that now. Because Anthony Kennedy is going to cast the deciding vote on that case, and I suspect he's going to come down against taking race into consideration anymore. That's my guess. I'm much better at telling you what happened in the past than I am in the future. But I think that what happened, so Waukee 78, it went up again in 2003 to the Supreme Court. The Supreme Court again said diversity is a compelling interest for the state in higher education admissions, and so you can take race into account, even though that comes with all sorts of bad historical baggage for doing that. But there was, Justice O'Connor had this curious sort of line in there that said, for the next 25 years. Literally, I've never seen a Supreme Court give maybe a case where the justices say, this is good law for 25 years. And then Thurgood Marshall wrote the dissent. He said, if it's bad constitutional law in 2003, it's bad constitutional law in 2028. And so I suspect it's going to be bad constitutional law in 2013. That's my, but I don't know. Anthony Kennedy will have the deciding vote, and it'll be interesting to think about in the context of Colley, who's obviously a big defender of affirmative action. Although I don't know how he thought about this really complicated issue of which other group. What Powell was doing in this case, he was saying the courts can't get in the business of determining which group has crossed a certain threshold of having a history of discrimination that merits, that grants them permission for affirmative action. And so Powell was saying, so forget about that. Courts aren't competent to adjudicate that. What I'm going to say is that what we can say is that an institution of higher education, a diverse range of viewpoints is reflected in diversity of the body is a good idea. So let's do that. And that's what Marshall was upset about. He's like, no. Affirmative action, as it was originally conceived, was about redressing the unique discrimination, the legacy of slavery that African Americans confronted. And I don't know where Colley stood on that particular issue, but it becomes a much more fraught issue when you're like, well, why these groups and not some other groups? When you make it about diversity rather than discrimination. Lots of questions here, and then I'll go around. Sorry. Yeah.
I was looking at Nat Colley's testimony for Anthony Kennedy's.
Oh, you have it there.
I have it right here, and it was just interesting because there was a part of me that got very proud because he mentioned my father, but also I thought because this is a Center for Sacramento History, it really mentioned Sacramento in a way that made me kind of choke up. And if I could read that one paragraph to you and then get your comments on why Sacramento may be different than Los Angeles and other areas. In responding to Senator Biden, he said this was 1949, and it was Archibald Mull, a local lawyer, and Mr. Kennedy's father, who at once took steps to see that there were no barriers placed before me, and in fact, they encouraged me to apply for membership in the American Bar Association. And of course, I was accepted. You will have to remember that at the time I am talking about, black members were not welcome to the Los Angeles Bar Association, but in Sacramento, my welcome was complete and total from the beginning, largely through the work of two people. That was Archibald Mull and Mr. Anthony Kennedy Sr. What was it you believe about Sacramento that might have been different? I mean, he came back to his wife's ancestral home, but was there anything about our...
Well, if the alternative was Alabama.
Was there anything about our fair city that was perhaps different than Los Angeles?
No, I think you would find, Lauren Miller is sort of launching his legal career in Los Angeles. You would find well-intentioned white folks Many of them were lawyers. They're racial liberals. They were a small cadre of people. Many of them were well-educated and well-placed. I don't know if Sacramento is unique on that front. These groups that were forming, these anti-racist groups, like the California Federation for Civic Unity and its chapters in cities, right, they're across California. So I don't know if Sacramento was unique on that side. I also don't know, I was asking somebody, when he moved to the part of Sacramento where he was integrating the neighborhood, my understanding, and that actually happened right around the very same time that Willie Mays was trying to buy a house in a white neighborhood in San Francisco. And they both experienced pretty intense discrimination. So I don't know, both on the racial liberal side, Sacramento's not unique, but I don't think it's any more unique or less invidious on the other side either. Colley experienced it. Willie Mays experienced it in San Francisco in 1957 when he was at the height of his sort of fame as a baser, and bought a house in San Francisco. And the neighbors then prevailed upon the seller to renege on the deal. So I don't know if it may be. I know there's an allusion to Sacramento being unique at the end of that, at the end of the documentary in terms of its demographic diversity. Whether that translates to, there's demographics and then there's interactions, right? Like how much that actually is reflected in the populations of the schools, the neighborhoods, so if it does, then Sacramento's unique beyond its demographic numbers.
I think excuse me.
Yeah, please.
I think the time diversity index indicated that yes, despite the fact that New York, San Francisco, the cities have the same level of population diversity, they found that the interaction in terms of neighborhoods that were integrated were more intense in Sacramento than other cities. And that's what gave it the edge of the diversity. In other words, you could go to any neighborhood in Sacramento and see a wide variety of people living in those neighborhoods.
And in the schools too.
Schools too as well. Yes.
I have someone shaking their head over here. But, yeah.
Well, to some extent, that's a function of size and of scale. The larger metropolitan areas are going to have higher indexes of segregation. So that's part of the story there. But my question is about comparing California to New York, where presumably the same kind of ethnic diversity existed, maybe Puerto Rican issues rather than Mexican, not quite the same history about the Asian issues and land and all of that. And whether we would see the same parallelism rather than intersection, or if it would be different in New York.
Yeah, I think it's a great question, and I think the standard book on New York civil rights history is a book called To Stand and Fight by Martha Biondi, who teaches at Northwestern. I was out there last year at a kind of conference on rethinking civil rights history, and I read her book, and the book is solely about black and white New York. And I went to her, I said, did you ever see West Side Story? So, I forget her answer, but, and it's a great book, but it was sort of, so that book doesn't really engage that issue. I suspect that this kind of dynamic, that, it's a pattern that you see of what I call civil rights raking in a multiracial setting, is not unique to California. It's probably, you'll probably find it in places. You see it in Seattle. You probably find it in Chicago, which is a large Mexican population from the early 20th century as a result of the Mexican Revolution. New York has it because of Puerto Ricans, also Chinese, also so I suspect that this kind of pattern, if you look more carefully, it's more widespread in a place like California. But I don't want to say it's unique to California. I don't want to isolate California off on an island of exceptionalism, right? I want to say that this is a pattern that actually was, it's contemporaneous with what's going on in other places, or I encourage other people to study those other places. I'm on a whole different thing now. And it certainly will become, I think, increasingly a pattern going forward as the rest of the country begins to look like California demographically. But I don't know the short answer.
Right, and the issue in California is made more complex because of the role, the ethnic niches in agriculture, for example, which might not be quite the case in New York.
Agriculture, yeah. But the Puerto Rican thing is there, and the language issues, and the kind of dubious citizenship status, and
one of the things that Nat Colley was also spreading out towards other ethnic groups. And one of his law partners was a Japanese American who later went to the bench that he kept. Miki Tanaka was one of his secretaries. He kept her for years. His law firm also represented Mexican Americans with job discrimination at the Port of Sacramento, things like that. The thing that really struck me about him was at that time you had Lincoln Republicans here in this town. And he had clients like MOOC. And I was able to share a lot of the nuts and everything that he brought from his ranch at that time to the family. He had so many that he would give me some. The other thing, black legislators at that time were heavily mixed up with other ethnic groups. I wrote a thing on racial discrimination and apprenticeship training. And at that time, it was Assemblyman Mervyn Bimley who said, you have to get Mexican Americans, you have to get Asians, Chinese at that time. When we held committee meetings at that time, there were people that testified on behalf of that. One fellow from his testimony was Benicio Morales. He was able to get federal funding from the testimony of, I can't remember the Mexican American that we got to testify. But even in the Mexican American marches on the Capitol, various black legislators were there, not completely, but maybe from Stockton to Sacramento. You know, there was a lot of support between ethnic groups, and I think that Cruz Reynoso could tell you that more than anybody.
Yeah, I hope I didn't come across as saying that wasn't, there's sort of this tension between that, which was there, and then and most of my focus is on sort of these kind of the Japanese American Citizens League Community Service Organization, and when they meet and they sort of get together and they say, let's outline our top legislative priorities for this year. And fair employment will be there, fair housing will be there, but it's a different, it's rank ordered differently. And when it comes to sort of saying, all right, where are we going to expend our effort? Our limited resources. It's at that moment where this tension sort of, the balance shifts to a kind of a multiracial vision and ideal to making hard choices about which specific pieces of anti-discrimination legislation or litigation to pursue. I don't want to discount that. And I try to kind of get that sort of that element. And why doesn't that?
Could I have one more thing?
Of course.
Archibald Mull used to speak very highly of Nat Colley. He thought that Nat could have been like the Melvin Ballet. All they had to do was hire people, have them come in and do it. But the thing about him wanting to be a country lawyer was true. He didn't want that. He was happy the way that he was. The part that you never mentioned is when he did get #1 law test, the one thing that happened, his first job was not with any law firm or anything, it was packing books for the State Board of Education he sent out. That's the only thing he could get. One of the first other people, other than Archibald Mull, that I used to hear and never met, I did meet Mr. Mull, was a fellow by the name of Jack Skinner, who was the head of the Bank of America here. When Colley went in to get a loan, he had no problems, and he always felt indebted. He had an awful lot of white friends. He even taught a woman by the Nancy Reagan, I don't know whether she's here or not, Reardon. He helped her when she became an attorney to learn women's law, and she became quite successful at that.
She's in Florida.
She's in Florida now.
On vacation.
Yeah, she's in Florida.
Yeah.
Heather.
I just wanted to comment to connect back to Mark's talk. Nat Colley did write a speech called The Meaning of Balking, and I believe it's on the online exhibit, and if it's not, I will make sure that I put it there.
Well, Colts then. Okay.
Well, I just want to say that Nat Colley was such a great lawyer that most of his clients were minority. They were Anglophone who cared about his reputation, and he had the reputation of being the best trial lawyer around. He had so many cases that the lawyer said, he always starts sort of slow, but by the second day, he really knows his case well, and invariably wins the case. So that reputation expanded. But I do want to support what was said a minute ago, and that is, for example, I belong to the CSO chapter in El Centro. I started practicing law, and we work closely with the NAACP, in part because geographically, African Americans and Latinos are all on the other side of the track, and so many of the issues were very much the same, so there was a lot of cooperation. You're right, I think, in sort of the big priorities, because as you say, the CSO focused more on issues that affected
the farm workers, and urban Latinos also. Most of the chapters were actually urban, and pushed those matters in Sacramento. But as you suggested, the matters of fair housing and all that was always part of it. I remember Murph Diamond coming down when we were fighting for fair housing, and the CSO chapter was very active in that, as well as the NAACP.
All right, we can continue the discussion in the next room. We appreciate everyone for coming, and please give our speaker a round of applause.